for a higher juicy news. Mima Obibia Aquaba, latest hot and one Aremeyaw bro. Now, Sana is summoning in a bebaro. So now subscribe ya, Bomodia say over subscribe. Now, while I give video, don't give us a thumbs up, nafi share now or fufrosu. Now, when you be here now, and someone ekoso ewo Ghana memohano. Afi you share a year and someone abeto yeponoso. Inti a year, some kumu a year, Sansemoya babitu ya moma inti dia ekoso, inti zemono.
Storming in, so not all the pink sheets and the various ballot papers for the polling stations were added to the initial one. So 41 was under contention at the time. Now, we've come to a substantive issue where even the minority leader goes on to make a statement about the judiciary, which puts its reputation into disrepute. When we know that over the last, I have to say 2 years, the performance of the judiciary had been a subject of public scrutiny in the eyes of the public opinion. So how do we just oppose that with us? His opinion and the outcome of this?
First of all, we shouldn't allow the MPP to set the agenda for anybody.
You mean, you think that's what they are doing?
That's what they are doing, especially Afenyo. We should not allow him to set any agenda for anybody. Okay, because you see, the facts do not support what he sought to do the last time. I've said that his weak leadership is what has collapsed the MPP. The truth of the matter is that in April of this year, April 2025, there was a ruling from the same High Court involving the Obuasi East parliamentary issue. Is that not the case? Remember, the returning officer in Obuasi East had originally proclaimed the NDC candidate as the winner, Samuel Abuaje of blessed memory, as the winner of election 2024. When he went to court, judging by the argument of Zaato and Afenyo and co, it means the court should have upheld what was proclaimed at the constituency level, if the court was that biased. But the court said no. In spite of the fact that the returning officer proclaimed the NDC candidate as the winner, the facts did not suggest so, so they overturned it and made Boakye Addo as the winner of that election. At that time, I didn't hear MPP and this minority go and make any press conference to say that indeed the said judge was what?
The kangaroo judge.
Kangaroo judge also.
But why is this an
was playing to the gallery? Now, I just want to disprove this fact that that has not been the case. Cases have gone to court where MPP has won some. This one is not even a victory to anybody. He said, rerun. Who has won in this Panda case? The course they go back and have another election, say someone has won.
Well, they are contesting it.
Yeah, but the point is that in Sawam 2, you remember in Sawam Adorye, did the matter not go to court? Judging by what Afenyo did, it means the court is a kangaroo court, so they should have affirmed the position of the NDC. What did the court say? Did the court not say that Another won? Did we hear the NPP come and organize such a bogus press conference to disturb the peace of everyone? In any case,
a whole minority leader.
In any case, like Edudzi has said, this whole case, they filed it somewhere in December before they withdrew. In December, who was the president of this country? Was it not the MPP? So it started from their time. It started under the embattled or removed Chief Justice. They assigned some of these judges by his utterance. Is he saying that the judge that was assigned during the Eswal administration was also a kangaroo judge that was deliberately put there to do mischief? That cannot be the case. You went to court. And let me say that we must not sacrifice or shortchange the will of the people under any circumstance. That people wake up early in the morning to go and queue to vote for a particular candidate. Now, a returning officer who is influenced sits somewhere and then shortchange the will of the people. Is that what you want to promote? Nobody must entertain that. So that if an election is held and any person feels aggrieved, elections are governed by rules and laws. So that the returning officer flaws anything, you, the affected person, must not pick arms. You must challenge the status quo. Go to court. But have you forgotten that Afenyo, who organized this press conference, was urging us to be going to court? Go to court. If there is anybody who has benefited substantially from our judiciary, Afenyo, he could go to court.
You can't make this allegation.
He could go to court.
So you can't make this allegation.
12 o'clock by 3 o'clock, he has an answer. In fact, he was able to cause the Supreme Court to a panel on a Friday in the history of our court. And he's the same person bastardizing the judiciary.
But there were officials of the judiciary who made those decisions.
You see, when you are led by someone...
See, like Solo is saying, no, I mean, it's important we bring clarity to this. Like Solo says, look, I have practiced small. At least I'm in my 12th year.
It's enough.
Look, I have never, in the last 10 years, seen the Supreme Court sit on Friday. I've never.
Or impaneling in 2 hours or 3 hours?
Look, not only that. You have a situation where a person issues a writ by 12 noon. By 2 p.m., 2 hours later, there is already a pronouncement, a panel. When was the last time you saw that?
So let me come in.
Nobody described what happened in that time as kangaroo. Nobody.
So Afenyo cannot
privileged.
Be the measure. Someone who will be preaching us about kangaroo.
Is senior to Edudzi?
No, but if you are seen, there are a lot of seniors around who are just misbehaving in this country.
Executioners don't lie supinely.
Senior to Edudzi.
There are a lot of seniors whose criticism must be withdrawn. A senior who goes to conduct a press conference without any evidence. At the time he was organizing that press, or he was reading his press release or press statement, he said he had not seen the judgment. So based on what was he commenting? You have not even read the details of the judgment, yet you were concluding. After concluding, the very institution that you have bastardized, you went back and claimed that your appeal is with them. As we speak, where have they gone? Is it the Supreme Court? Is the Supreme Court not part of the judiciary? The very institution that you claim is a kangaroo institution, you are still back there. You are going there to ask it to quash a whole ruling. Based on technicalities, it tells me that the MPP has realized that on the substantive case, they have no issue.
Why do they not have issue? You saw Martin Yindam, he says that he's still the MP substantially also.
Well,
he's ready for a rerun.
He's not ready.
He's very confident.
He's already.
You know the voting pattern, the differences, Solomon also.
I mean, historically, if you look at the records, the NDC has held that seat the longest. I mean,
from Honorable Tawali,
yes,
and
the longest. So I'll be very surprised. I'm coming, and so
the caretaker MP.
The NPP is afraid, especially where their internal flag bearership has also divided the party to the.
You think the party is worried because of their internal?
Nyinam and the Northern Caucus MPs have aligned with Dr. Mahamadu Bawumia.
But what's wrong?
So the problem here is that how are you going to get the lives of Brian and then Agyapong, especially where they have moved from sinners business to medical conditions to now motherfucker? Did you hear that?
No, on the campaign trail.
On the campaign trail.
Motherfucker. These are the motherfuckers that are in the court.
But that's a campaign talk.
That is so. Did I tell you, Atachia, an elder of the, he's an elder of the church. Oh. He's telling you that we are going to hear, motherfucker.
Are we still talking about Kwanda? You are talking about
he's making reference to one of the candidates.
Who is that?
It's Ken he was referring
So if you are calling Ken motherfucker, how is he going to go to Kwanda?
But that is sanitary language that he was using against to score political points.
But
and it's been condemned.
I didn't expect an elder to be saying that, to be repeating that.
So you are saying that because of the division in the party?
In the MPP primary, there have been scenes of the various candidates.
So the point is that
the upcoming DC primaries here. We've not talked about that.
So today you will not allow me to speak.
Gentlemen.
Did I come here to ask it what you people?
Okay. So are you making claims?
Yes.
Which I think you are not substantiating. To regroup. No. Is that going to do playoffs again?
That's the point.
And you are saying they can't gather the right players.
The point is that the Brian faction, the Kennedy faction would never join This campaign.
Nyindam's campaign.
Nyindam campaign.
Are you sure?
Especially when Dr. Mahamadu
You just
Bawumia
left the MPP about 2 weeks ago, and you are here saying
has promised them that he would deliver the Northern votes. So the Ken and the Bright campaign, the camps are saying that you said to the entire world that any election in the Northern region, you would deliver it for the MPP. So Dr. Mahamadu Bawumia, go and deliver the Kwanda seat. That is the bane of contention here. That is why they are doing everything possible to use technicalities to quash the ruling.
You are making claims that they are undertaking legal gymnastics.
It's legal gymnastics.
Apparently, Roland, they are waiting for Nyindam to lose the Kwanda seat.
Yes.
And then they'll
Why you think the NDC will win the seat?
Hold on.
For a rerun, if it should be substantiated.
They'll add it to the 11th sin of Dr. Bawumia. Failure to deliver Kwanda seat.
Roland,
You understand? Because now, hold on. Of all the candidate MPP
Today they have not made me to speak.
for the January 2026, January 31st, 2026 presidential primary.
You want to follow
that
Joshua?
each of the candidates has sins, and it's not one. Some 10 sins, 15 sins. Yours will be like 20 sins, Zaato's 20 sins, Bawumia's 10 sins, Brian Champion's 15 sins, Edudzi, you know. So,
but you then, are you ready? You've seen the margin. It's all in excess of 3,000. I think when I watch.
No, I want to say something.
It's in excess of 3,000.
we want it done. We are ready for the by-election.
So anytime you want.
The people who have applied for stay and they are in the Supreme Court of Appeal, they are not ready.
Roland, I'm really happy that this morning, Dr. Bawumia is living rent-free in Solomon's hired and hard.
Oh, how?
He's doing that. I'm happy that
How did I? But Roland, the point is no. I was on the floor. How did you allow them to come in?
We were talking about it. All of a sudden, you've ended. So I'm happy that
I know part of the discussion.
Look, the point I'm making is it coming down all this to Pandai. All I'm saying
is MPP ready for a rerun?
I don't.
How don't you know?
All I'm saying is this. I pray and hope that we do not reward violence and hooliganism. I pray and hope that we learn serious lessons from this and do not make Pandai a test case for other losing candidates.
Do you think that if this is upheld, where we need to have a rerun, just like the judgment of the High Court is, MPP will win those?
Again, I don't know about that, but what I know is that if this is upheld, it may become a copycat for future losing candidates. Future losing candidates may be, I don't want them to look to Pandai, to what happened to Pandai in their political planning next year or 4 years from this. I don't want a losing candidate to someone say, hey, you saw what happened in Pandai, right? They were losing, and then they stormed the place, and later, unfortunately, their party won power, then they got the ruling and stay the power. I don't want that calculation and that game to come out at all. I said, I don't know.
Think that the MPP will win
I said, I don't know.
Rerun of Pandai seat?
I don't know.
Okay.
So clearly,
what do you think that they need to do now? Do we need to have the court uphold what the High Court's ruling is?
No, as we speak, the court decision is that there has to be a rerun. There has not been any court decision to overturn the High Court decision. So what the parties have to do is to prepare for a rerun. But I've said somewhere that I am ready to sue the new patriotic party should they withdraw from these elections. The last time in Tamale Central, they got away with it. We are practicing democracy. It's a win or lose. It's not any time that you go into an election and win. They must go into Pandai and contest. If they win, hallelujah, I'll be happy for them.
But will you file a candidate?
No, our party had not. We haven't gotten our final certificate. We were not part of the last elections. We would have contested. There is no seat in this country that election 2028 we will allow it to go. You have been running away from elections. Tamale Central.
So they have to contest.
No, if they don't contest, I will sue.
They are holding the seat. So if there's a rerun, automatically they should win.
Yindam has given up.
3,000 plus.
Oh, no. Look, if they don't get the way they will give them that gap.
When the DG was, so there was something the DG said that actually caught my eye, and I'm You said a situation when you were going to court, when they started really, somebody told you that it won't go your way, and you prepared your appeal.
Notice of appeal.
You know, a similar thing happened, and Nyindam lawyers too are saying the same thing. They are also saying that they also got intel that it won't go their way, and that they had their appeal in their pocket. I am saying there is something happening here.
Okay, so what they did say was that they made a claim that on the day of the ruling, the regional minister came alongside supporters of the NDC.
Good. And the same thing. And
But is it not logical that if you're a legal team and you feel that you have a good...
What they didn't tell you is that the current Northern regional minister is our regional chairman. And
okay, he's the regional regional chairman.
The regional chairman elect of the NDC for Northern region. And the Konkomba by trial. Just as Nyindam and Insala, you understand? So they went there to give support. Moral support.
No, I'm saying today he's calling support. The point I'm making is that, but he made a point. I want us to see.
No, so I didn't see the reason why
his argument was
the whole idea that they were.
I want to even ask you whether you're going to win. You say you don't know. Everything about MPP, you are not running away from MPP.
This guy too kept his appeal in the pocket. Why are lawyers carrying?
If you are running away from MPP, because of the United Party, and you'll be free.
They had the opportunity.
No, you should join the United Party because that is running away.
Please, I have 12 minutes. Oh, everybody.
But today you have actually taken my time, given it to Zebudje and then Edudzi.
NDC. All right.
This morning,
what makes you think that I have access to it?
So that questions how he was made the minister of roads and highways.
Drink some water.
Let me drink it.
Today happens to be my very good brother, our Western Regional Communication Officer, Richard Kek Mensa, his birthday. So I think it's exactly at the corporate affairs, and today happens to be his birthday. So let me use your platform, esteem platform.
Brother, happy birthday to you.
Bleda. We'll meet in Takrady second day.
Okay. But the appeal by Martin Yindam and his legal team, what do you make of it in the first place as director of the legal directorate of the NDC?
Okay, so I want to look at it in this context. The laws of this country allows a person who is not happy with the outcome of parliamentary election to have that challenged. I think I need to put a certain historical context to it, maybe factual. If you recall, immediately after the declaration, our candidate, Daniel Nsala, went to the court, the High Court in Tamale. When he filed the petition, lawyers for Mr. or Honorable Matthew Yindam actually applied to the court to have it struck out as being premature. And their contention was that at that time, our candidate should have waited for the gazetting of the result before mounting the petition action. So quickly, the lawyers withdrew the petition so filed and waited until the Electoral Commission itself now gave an indication that on the 6th of January, this is the Gazette notification. So in an affidavit deposed to by Matthew Yindam himself, he attached what he claimed to be the Gazette by the Electoral Commission. He attached it to his application. Now, this application that Matthew Yindam actually put before the court, subsequent to that, the MP, that's the NDC parliamentary candidate, now issued a fresh, now issued a fresh petition after this Gazette. And if you look at the deposition by Matthew Yindam, one of the things that he said in his affidavit in support, which he swore to, and you see, when we say deposition, you swear to. What it means is that if you lie, you risk perjury. Now, in the deposition that he put before the High Court, one of the things that he said is that I just want to read, that available records show that the parliamentary election results of 7 December 2024 nationwide, including that of Pandai constituency, were published in the Gazette or gazetted by the Electoral Commission on 6 January 2025. Attached hereto and marked as Exhibit this is the page of the Gazette relative to Pandai constituency, a soft copy attached here too. So, pursuant to this, the NDC candidate then withdrew the application, the petition, and refiled it based on the 6th of January Gazette notification. Now, after the High Court in Tamale had delivered its judgment, after calling witnesses, both the Electoral Commission came to testify, he himself testified, through his witnesses, and our candidate equally testified. The High Court judge in Tamale delivered the judgment. Now you are the Supreme Court saying that at the time the NDC candidate filed the petition, the 21 days gestation, the 21-day period had elapsed. And for that matter, the High Court was bereft of jurisdiction.
What's your opinion? That there's no merit in this?
Completely without merit. Because, hold on, I've just read the affidavit
in
deposed to by Yindam, where he himself swore to the court that on my honor, the Pandai Gazette relative to Pandai constituency declaration is 6th of January. Now you are before the Supreme Court. Now telling the Supreme Court that no. It is not on the 6th. I lied.
Edudzi, I'm surprised at your
position
because
and that I have engaged. Hold on, I have engaged in perjury. And so when look, the deposition is before a superior court, the High Court. Always remember that an application for certiorari is a discretionary remedy. So even when you have satisfied all, the court can still deny you based on your conduct. And when you have deposed to an affidavit telling the High Court subsequently that I lied, that when I told the High Court in my affidavit that the declaration and the gazetting was on the 6th of January 2024, I peddled on truth before the High Court. How can you do this? And I'm surprised.
Because, the reason I was questioning was that this follows greatly what the minority leader had also espoused in his press conference and thought that the judiciary, based on his position and his assessment, was becoming almost like one that was being controlled or manipulated.
You see, when I heard my learned senior Afenyo Markin make that statement and described the whole thing as kangaroo, I felt pain within me. Look, I am not speaking about somebody's lived experience. My own experience. Look, I recall vividly our MP for Asenov, Jachi Kwesen.
The Deputy Foreign Affairs Minister. Okay.
At the time Jachi Kwesen, this thing came. Remember that we're going to have the speaker's election on the 6th of January, the night. So,
of 2021.
Yes. The High Court judge
2024
in Cape Coast, there was supposed to be a demonstration in Winneba. So the High Court judge in Cape Coast was given a special warrant, listen carefully, was given a special warrant to go and hear an injunction application to restrain the NDC supporters. Then they brought an ex-party application for injunction to restrain Jachi Kwesen. When the judge saw it, he said, this one should come on notice because you are seeking to restrain a member of parliament duly elected. Guess what happened? Our law firm represented Mr. Jachi Kwesen. Myself and my senior Amaliba worked on that thing.
The case?
The case. So we quickly filed affidavit in opposition to the injunction application before the High Court judge in Cape Coast. Guess what happened? We were clear because we had raised certain critical constitutional issues. That one, Article 94 which has to do, he owes allegiance to no other country but Ghana, requires constitutional interpretation. But because the last time it came up was Bilson and Rawlings, where the High Court judge took the view that the question as to whether a person owes allegiance to a country other than Ghana simply means that you cannot stop Jerry Rawlings from contesting the 1992 election because, in your view, Bilson's claim was that Rawlings' father was a Scottish, and therefore he was a dual national. The High Court judge, Bonzi, took the view that having served in the Ghana army and having become head of state for almost 11 years, it was ridiculous for anybody to now come and say that Jerry Rawlings was a dual national, and for that matter. So we felt that this was an opportunity for the Supreme Court to construe what it means when you say a person owes allegiance to a country other than Ghana. So in our affidavit in opposition, we raised those constitutional matters. Guess what? The day we went to the High Court on the 6th of January in the morning for the ruling on the injunction, we got to court only for the judge to say that he's granted the injunction. Listen, no, he's granted the injunction to restrain Gyamfi.
Was he untoward?
From 1972, even Moro, Igala, and the rest, there had never been any instance where, prior to the hearing of an election petition and concluding, the MP-elect had been restrained. Because we did the legal research, there was no search. Guess what? The judge restrained us, and this is where it gets interesting. But the day before, I had a senior party officer called me and said, Edudzi, I've worked within the national security setup. My intel shows that the injunction will be granted. So I said, senior, it cannot be. He said, no, Edudzi, leave that one to me. I've worked with the national security of this country. This is where my intel within government sources. So the injunction will be granted. So prepare. So myself and my senior prepared our notice of appeal and stay of execution before we went to court in Cape Coast. So while the judge was reading, while the judge was reading the injunction ruling, we quickly stepped out to go and file the notice of appeal and the stay of execution. The registry was close to us. We couldn't even get the opportunity to file the notice of appeal.
You mean the registry was closed or the registrar was not around?
Look,
none of the court registrars?
And you see, what we have seen in this country, my learned senior Afenyo Markin had no idea.
Oh, you can't make those conclusions.
No, he has.
You know that he's a senior to you at the bar.
Oh, completely.
He's been a long-standing.
Oh, no, he himself knows.
So you cannot make those suggestive comments.
Look, I respect his law. I respect his law. But he has no idea what a kangaroo judiciary looks like. He has no idea.
You mean he hasn't gone through those experiences?
He's never even gone through that experience. Why do I say so? Look, I have always maintained that my learned senior is a very privileged person. Do you know why I say that? In Gyamfi, I saw the other side of the law. Look, we'll leave Accra morning by 5 a.m. with Mr. Chachuchikata and our then national chairman Ampofo to the High Court. You know, then there was a court of appeal sitting in Cape Coast. We'll file stay of execution application before the High Court. Yes, I will. Before the High Court in Cape Coast, the Court of Appeal in Cape Coast. You even go there with Mr. Chachuchikata and unanimous by court, application for stay, so and so, dismissed. In fact, one thing that caught my attention, and I'll conclude on this. We had raised an issue in our notice of appeal and others. We've raised an issue that the matter on Gyamfi, which borders on Article 94, required the Supreme Court interpretation. So we made a prayer before the Court of Appeal in Cape Coast that, my lords, because there's an interpretation matter, by reason of Article 132, we plead that you stay your proceedings and refer that constitutional matter to the Supreme Court for interpretation. Do you know what happened? The Court of Appeal in Cape Coast denied us the opportunity. Said no, the application was without merit, blah, 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 blah. Do you know what happened? The same matter that the Court of Appeal refused us, we now went for a certiorari application at the Supreme Court to say that what the Court of Appeal did was untoward. The Supreme Court denied us the opportunity. Now, lo and behold, we were there, the same plaintiff whose lawyers has resisted any application for referral to the Supreme Court, now issued a fresh writ at the Supreme Court asking for interpretation, and the Supreme Court assumed jurisdiction over it.
Well, to you as an experienced lawyer, that's not good.
So you see,
Is that no?
So when I hear my senior Afenyo Markin made the point that what we are seeing is a kangaroo, I said, look, senior, you have no idea what we have lived. This is our lived experience. Look, imagine somebody like Senior Chachuchikata. You will leave Accra by dawn, 5 a.m. And by 7, we are in Cape Coast Court of Appeal. We're just being tossed here and there, until finally the Supreme Court, which had earlier in an application for referral refused us, now says they have jurisdiction to interpret Article 94 relative to Jachikwese, which eventually led to them, saying that he is not qualified to be in Parliament. Then we had to go for the by-election.
And so your contention is that...
So my contention is that we've not even gotten to the point where anybody can describe what has happened in the Matthew Nyindam, conversation as a kangaroo judiciary. No, it is not a fair assessment of...
I want to build on where he just landed. So it's obvious that depending upon where you stand, where you're sitting, you have serious problems with the court.
I don't understand.
From what he just said, when they were in the position, they didn't get justice, or they saw the other side. He kept saying the other side. He's a practicing lawyer, probably he doesn't want to go to the other side. He kept talking about the other side of the judiciary. He's not mentioning, but you can read from him. He's saying that there were things that happened to them because they were in opposition. That is what you get.
Is that your understanding of mine?
That's my understanding. That's my understanding. What he's saying. Now, you've also heard Afenyo Markin also saying that there are things happening to them now that because they are in opposition, it looks like kangaroo court. We now have a situation in this country, which is where we've got to right now, that if you are in government, you almost always agree with what the courts are saying.
You think that's why Edudzi is doing?
Almost all the time. And then if you are in opposition, you almost always think that the courts are out to get you. My question is, that cannot and should not be justice. Justice should be, it shouldn't matter whether you are in government or whether you are in opposition. It shouldn't matter where you stand. It should matter that people should be able to read judgments and be able to, it doesn't matter. People going to court should be able to say that, look, it doesn't matter where I am, I'll get justice. But so far, it doesn't seem to be that. That's my number one thing. Number two, politicians in Ghana, and especially MPs, are almost always hell-bent on politicizing the court. And they've done that successfully over the years. And now, sometimes it's funny, they themselves, sometimes led by lawyers, they politicize the court. And then immediately after that, they are the same people who will run to the media to now talk about politicization of the court. When the NDC was in position, there were even times where they will march up at the court. You've seen that. You've seen MPs literally march to the court. What are you doing marching up to the court? It's a form of political intimidation. We've seen that. Now we've seen a similar thing happen again now that when they did that, MPP that was in power, they criticized it. Today, a similar thing is happening. The same NDC MPs are now in parliament, they are okay. It's the MPP who are now also marching up to the courts.
So what do you think should be the status?
My point is that why? There has to be something in the water that when these people drink, that it makes them behave this way. Or is it that, do they have reasons to believe that when they are in opposition, either party, that they don't get justice? Do they have a reason to believe that? If they do, then something must be done, especially since they are the lawyers. They are those people who go
during the period of the Jachikwese case, were you in Ghana or you were in Canada?
Yeah, I was in Ghana. In Ghana.
What did you make of the seemingly some of the instances that had been portrayed on public discussion platforms at the time, and then also that he had made reference to on this table in terms of how the processes of whether it was filing or also using the various tools or that you have within your remit as a lawyer or somebody who is a plaintiff?
Again,
to be able to seek some remedies.
As a non-lawyer, I don't want to go into some of these intricacies. Then
I'm not asking you to comment on substantive cases.
Yes, yes.
I'm talking about the public opinion items that became very key in people forming their judgments.
Okay, so this is
about
the point.
How, let's say, Jackie Kwesin's case was.
That's where I'm coming. It seems to me, again, I'm making it broader because I cannot be very specific because I don't know the nuances.
You said you were in Ghana.
I was in
Please
Ghana.
make it.
But he was in the court and he has privileged information. He was in the arena. He had privileged information. I don't have, because if probably the only person that could speak counter to what he's saying will probably be the opposing lawyer. Then he could say, me too, I was there. I wasn't there, so I cannot be that specific. I agree with you. I'm not privileged with that information, so I cannot be that specific. That's why I'm talking about the general issues that we look. Everybody agrees that we need some legal reforms. So why is it not happening? If all political parties have not agreed, those who have ruled this country, say that when they are in opposition, they don't get justice and fairness, but it seems when they are government, they get. Why is it that? That is something that the Ghana Bar Association does, especially we now have a new Chief Justice, and the Chief Justice who is likely going to be there for a year. He has a lot of work to do to try to demystify it, if it's a mystery, or to try to depoliticize the court, because we have no other option. And I know that politicians will not do that. But there's one thing that always worries me, that the same, and I want to talk about it, and Edudzi is here. How come a judge, then after all the arguments, you say, okay, I'll give a ruling on Monday. They will come on Monday, he said, this is my ruling, but I'll give you the reasons on Friday. Why?
It happens.
Well, so I'm not saying it doesn't happen.
So let me give you a classic example. You know, in the year 2020, the Electoral Commission decided that they will change the old voters' card. So I was counsel for the NDC, and we went to the Supreme Court. When we went to the Supreme Court, the court heard all the argument and gave its orders and deferred its reasoning to another day.
I'm saying it's common. It's one norm. My point is why?
It's a norm.
My question is why? Because I don't understand
it. It's a norm.
Why do they do that?
So you don't raise why?
I am.
The judge will give the orders and defer the reasoning to another time.
Why?
It's a norm.
Good. My point is, why can't the judges do both? Issue the judge and give the reason on the same time. Is it a matter of time?
No. I was surprised that my senior Afenyo Markin then raised issue. Recently, this Kwabena Agyapong,
yes,
he went to the Supreme Court to challenge a decision by the High Court judge on disclosures. You recall?
Yes.
The day they went to the court, the Supreme Court delivered its ruling.
Yes.
Refusing the certiorari application and the prohibition.
That seems to be the norm.
And deferred its ruling to another day. So it's a normal.
Again, I'm not saying it's normal, and I'm not saying it's associated with one particular.
I want to know why.
I'm saying that they keep doing that. Why?
Okay.
Because see, as an academic, I get a paper to review, a manuscript to review. If I'm rejecting it, I don't send it back to the editor and say, I'm rejecting this, but give me 2 months or 1 month, I'll come back and tell you why.
Because you have to write a judgment.
Exactly. No,
but you have to write a judgment.
So is it a matter of time? My question is it a matter of time? Is that why they delay? Is it a matter of time?
They have to write the judgment.
I agree. So is it time they want? Is that why they give one and give later? If it's time, you are the judge. If I know that I cannot give my reasoning in 1 week, I'll postpone the case too long.
Is it your thought that perhaps you think that period where that vacuum is created creates something?
It creates a lot of room for wild
speculation
and conspiracy theories. And now my argument then is that grace period leaves to people to now wait until, and that also contributes to undermining of the judiciary, because now we are talking about something that we don't know. All of a sudden, look at, I saw almost everybody when this Jody Limba's this thing came.
Yes.
When people were, but the moment it came, we were like, wow, this so far everybody said this an excellent. So my question is, couldn't both had happened if it was time that was restraining the woman? If she couldn't do it at that time, why couldn't? So I think that the judges or the judicial system is not doing itself any good by creating this amount of room for people to now conjecture, for people to now come with conspiracy theories, and then you come out. It's not that. But thirdly, I'm coming to the actual case we started, because again, I'm not allowed to.
That's the
Nyendam case. For me, it seems increasingly our political system, electoral system, is beginning or always trying to reward hooliganism at coalition centers. When we started this democratic experience, the problem was snatching of ballot boxes. You realize that. All of a sudden, that has disappeared. Nobody is trying to snatch a ballot box again.
It happened in the last election.
Yes, I'm saying it's almost
even in 2020.
It's not a major issue now. The reason why I'm saying this is because the reason why I'm saying this is because the reforms we've done as a electoral process have come to make snatching of ballot box almost redundant. Because even if you snatch the ballot boxes, all the candidates have their pink sheets. It's also being recorded. So the violence is now, and the hooliganism is now moving to what? Coalition centers. In all of that, so if you look at almost all the things, people storm, because if there are 5 police stations in this constituency, and by the time, sometimes because of the distance and everything, by the time we are going to the coalition center, I know what I'm winning or losing. One, no winning candidate will storm a coalition center to stop voting, to stop counting, because he already has his pink sheets that he's winning. It's possible only losing candidates and their people storm coalition states to prevent this from happening. My point is that, and in this particular case that we're seeing in them, if you see who stormed the police station, who stormed the coalition center, and there are videos to show that it was NDC people in the pickup who stormed the place, necessitating the moving of those positions to Tamale. It shall be declared there. My point is that if we don't do something, national security, election security, all IPAC and everything, we must be able to provide coalition centers as fortified security zones. Make it almost impossible and impenetrable to prevent hooligans from storming that place to disrupt. If not, almost every losing candidate will copycat. We shouldn't let Pandai be the test case and be a copycat case. We shouldn't let losing politicians in our elections copy what happened in Pandai, because if we let that happen, we are going to see those cases. And so for me, this should be something one I think we should learn to make sure that from now onwards, let's create coalition centers that are impenetrable, that makes it almost impossible for anybody to storm and disrupt it. If that had happened, if the security and safety, that is why, look, in this, sometimes I always say, I praise the police for what they are doing. But in this particular case, the police did not cover themselves in glory with what happened in Pandai. Because once you allow people to penetrate there and do this, they didn't do well. So going forward, our national security, our police and election task force must be able to ask themselves, how can we create coalition centers that are so safe and secure that we do it? Because if we do that, we will not be where we are today. Okay. And that is the only lesson we can do, because if not, we will be rewarding hooliganism.
Thanks for watching. Like and share the video. You can also drop your comment. Please don't forget to subscribe. Click on the bell to turn on the notification.